Mr. Gilbert, have you had a chance to review the charging document?
Yes, we're aware of the charges against my client. We wish to waive the reading.
How's he plead the charge?
You'll stand mute.
He will enter a plea of guilty. I'm sorry, will enter a plea of not guilty for Mr. Isler on the charge of fleeing and eluding fourth degree, 2 counts of resisting, obstructing, misdemeanor operating while intoxicated and open intox, and there's a habitual fourth notice as well. Is a forensic center referral requested?
It is not.
Estimated length of trial?
Again, I believe a jury pick would probably be about 2 days.
And, can I see this one? And appropriate for docket call on February 10.
Yes, just to inform the court, I have ordered the transcript and I'm waiting for that for a possible motion.
Oh, okay.
So that will be forthcoming once that transcript is received.
Very good. If it's necessary, if it doesn't give you enough time to receive, review the transcript and file the motion, just I'm sure the prosecutor will step to dismiss or step to, I keep saying things wrong, step to adjourn, or you can file a motion to adjourn.
I appreciate that. Thank you.
Otherwise, I'll schedule this for a docket call on February 10 at 2:20 in the afternoon. Anything further from the people?
No.
From the defense?
Yes, Your Honor. I would like to ask if the court could review possibly the bond in this case. It's currently set at $75,000 cash or surety. My client is unable to make that dollar amount. The court would consider a lesser amount. I know he's here supported by his brother. His brother has informed me that there would definitely be a place for him to stay at his house and accept responsibility for him to make sure he's here for court and that type of thing. So we'd ask the court to consider a lower dollar amount in this case. Thank you.
Is what counties Mr. Isler, he's got a Sheboygan address in the charging documents. Is he a Sheboygan resident?
He is.
Read the point here. All right, Ms. Goodrich, people's response.
Your Honor, I'd ask that you deny the request due to the nature of the offense. The defendant is 40 years old with 3 prior misdemeanors, but I see 2 of them were in 2024, no license on person and drunk and disorderly. I'm not sure if those were while he was still on probation in district court. And part of the reason for the high bond, the prosecutor handled the arraignment. He also has the 3 prior felonies as listed on the information.
Look at the bond.
It looks like I do have a note here that he was on bond for an OWI, but I'm not sure what county, if that was ours or another county at the time of the arraignment on October 10th.
Mr. Gilbert, do you have any knowledge about that?
Yes, he was on bond for an OWI. That has been resolved and time has been served on that. And that was in district court and he pled.
One of the conditions is SCRAM alcohol tether. Ms. Goodrich, is there any was there any indication of drug use in this case, or was it alcohol solely, do you know?
Alcohol.
All right, I'm going to reduce the bond to $25,000 cash or surety in full amount. I don't think a PR bond is appropriate, given that he was already on bond for misdemeanor OWI at the time of this incident. It'll be subject to the same conditions, meaning Mr. Isler, you'd have to have a alcohol tether on your ankle in place prior to release from the jail.
Yes.
And I'm going to tell you, any tampers or any alcohol readings on that whatsoever will revoke your bond immediately. I won't do a show cause, Mr. Goodrich. We'll just do a warrant. If there's any issues with that tether, I'll do a warrant for your arrest and you'll have no bond. All right. All right. We'll see you February 10th at 2:20.
Yes.
Great. Up next, we've got People of the State of Michigan versus Dennis Brinigar. It's filed 2021-6092 FH. Counsel, you want to state your appearances beginning with the people?
Good afternoon, Your Honor. Susan Dillon on behalf of the people.
Good afternoon.
Good afternoon, Your Honor. Attorney Daniel Groh, P48628 on behalf of the defendant.
All right, good afternoon, sir. And Mr. Brinigar, Mr. Groh, you're appearing by Zoom from separate locations. Let me know if you need a breakout room at any time to talk privately. This is a continued status conference after a remand from the Supreme Court for this court to conduct a Ginter hearing on two issues involving alleged ineffective assistance of counsel. I continued it so that Mr. Groh, your substitute counsel, so that you could determine whether you wanted to go forward on your predecessor counsel's brief, or whether you wished to file a supplemental or I guess either a supplemental or a superseding brief on those two ineffective assistance issues. Have you had a chance to review the file enough to make that determination?
Well, Your Honor, I first need to apologize. I was a little aggressive in my estimation of my ability to get as much done as I expected to get done by this point. I think that was even the judge, I think Your Honor said, "Are you sure you want the next hearing that soon?" And I said, yes. But at the same time, Your Honor, while I haven't completed all of the due diligence that I intend to complete, it seems to me that the dissenting opinion from Judge Shapiro very closely aligns with the remand order by the Michigan Supreme Court, especially with regard to the first two issues covered by the judge. And really the essence of a Ginter hearing is that the factual record is not available, an evidentiary hearing was not heard, and that needs to occur. So while I would be happy to do something that would be very similar to Judge Shapiro's concurrence, I think the far more critical issue is to get the evidentiary hearing scheduled, and then I would certainly be happy to provide the court with a post-hearing brief that harmonizes what leave was granted upon and the testimony of anticipated witnesses, Your Honor.
Okay, so let me know if I'm understanding that rightly, that you'd like me to schedule this for the evidentiary Ginter hearing without the need for additional briefing at this time, and then at the conclusion of that hearing, I could invite further briefs if it seems appropriate. Is that what you're saying?
Yes, Your Honor.
Any objection to that approach, Ms. Dillon?
No, Judge, I think that's fine.
Okay, so Mr. Groh, how much time do you believe that you would need for the Ginter hearing? I'm not asking how soon you want it. I'm asking how many days or half days do you think that you would need?
I think it would be appropriate to set aside a whole day with the goal of not using the whole day, but having it available.
Okay. Ms. Dillon, do you concur that setting this for a full day evidentiary hearing is our best next step?
I think so, Judge.
Okay.
Now, Your Honor, I must interject one more time if I may.
Yeah,
I have a murder trial with some 40-odd witnesses scheduled for March. The court in Berrien County has set 3 weeks essentially for that trial to take place, taking up most of the month of March. And obviously, leading up to the beginning of March will be a very compromised period of time for me because I'll be devoted to trial preparation almost exclusively for that matter. So I just wanted to throw that out there before we started looking at dates.
okay. Well, that means you probably don't want one in mid-February for 2 reasons. One, it'd be pretty close to where we are now and maybe a little too close to that trial in March for you. Is that right? Yes,
Your Honor, regrettably. The timing's awkward. I appreciate that.
Okay. I believe that I could give you Monday, April 27th, if that gives you enough time at the conclusion of that trial to be ready to go on this.
Absolutely. And of course, trial counsel's availability that, he'll obviously is the primary witness for the Ginter hearing. I will contact him immediately, and I can contact the court immediately if he tells me he's starting a murder trial that day or something.
Okay. Well, why don't we tentatively schedule this then for an evidentiary hearing on Monday, April 27th, beginning at 9 a.m. That'll be in person. If there's any witness that either of you wish to testify by video, check with the other side and see. I require either a stipulation or a motion about that. Otherwise, I'll expect everybody to be in person for that hearing. Anything else you need me to do today, Mr. Grove?
No, Your Honor. Thank you very much.
If you find out that you've got any scheduling problem with either yourself or trial counsel or any other witness, just contact Ms. Dillon and my assignment clerk, and we can get a phone conference with me anytime to talk through alternate schedules, okay?
Thank you. And just when we're off the record, are we off the record, Your Honor? I just wanted to talk.
We're not off
with
the
my
record.
client very briefly before we ended the Zoom call. That's all.
You wanted to what?
Just talk to my client very momentarily if we're off the record.
Okay. I can create a breakout room for you guys to talk once we're all done, and then you can just leave the meeting when you're all done talking to them. Okay.
Thank you very much, Your Honor.
All right. Anything further on the record from you, Mr. Grove?
No, Your Honor.
Ms. Dillon?
No, thank you, Judge.
Okay, so Mr. Brinigar, I'm going to create a breakout room for you to talk with your attorney. When you're done talking, you're free to just leave that room. We're not going to go back on the record in this case, okay? That'll bring us then to People v. Courtney Self, file 25-7089 FH. And Mr. Gilbert, we're here for a docket call, and we also have a show cause. What's our status on the docket call?
The prosecutor has provided me with a plea, and I provided that to my client. And also, however, when talking with my client, she is informed me that she's intending to retain counsel. So she would like an opportunity to do that.
Okay. And Ms. Self, it's alleged that you are in contempt of court for violating conditions of your bond by not calling and not testing. You have the right to have a hearing on those allegations where they would need to be proven beyond a reasonable doubt, the right to the assistance from a lawyer, and to present evidence in your own defense. If you are found to be in contempt, I could jail you for up to 93 days. I could fine you for up to $7,500 or both. Also, if I believe you're not complying with the conditions of your bond, I can revoke that bond at any time. Do you understand the rights that you have and the maximum penalties that you can face?
Yes, Your Honor.
Mr. Gilbert, how she was to plead that?
She would like to request a hearing at this time, Your Honor.
We'll enter a plea of not guilty to contempt. We're going to schedule this for docket call and a status conference on the pending violations on February 3rd at 1:30 in the afternoon. Then you going to have an attorney by then?
I should join.
And I guess given that Ms. Self just seems determined to not comply with testing at all, I'd like to hear from both sides about what I ought to do about that thing.
Your Honor, bond is set because it's a privilege and there's conditions to given in order to not be incarcerated, and she has chosen not to follow those conditions. So I'd ask that her bond be revoked.
Mr. Gilbert?
Well, Your Honor, I think we're here on these two instances, 11-18 and 12-1. I don't believe that there's been any, unless I'm incorrect, there's been any violation since the beginning of December. My client has supplied me with a few documents. I've just received these. That one does look like there was a test on 11-18. And it looks like Harbor Hall was closed on 12-1. So I haven't presented these to the prosecutor. Again, I just received these. However, it looks like there might be a defense to some portions, if not all. So I would ask the court to maintain bond, and if she violates hereafter, then revoke at that time.
Ms. Self, I mean, there's the show causes that we've got, and I don't want you to tell me anything about those, but then see, just the report shows plenty of days that you're not even picking up the phone to call. 11-27, 11-28, 11-29, 11-30, 12-6, 12-7, 11-22, 11-23. You don't get to do that.
Your Honor, I check in on.
I don't want you to tell me about it. I'm going to tell you this. I'm not going to cancel your bond today. One missed call, one missed test. I don't care. Sunday you're calling. Every day I get one report that shows any problem in this. I will sign a warrant. We won't have any other hearing until you're arrested.
Absolutely, Your Honor.
And you'll sit for the whole case. Okay, you have to comply with this. This is not optional. You don't get to decide when you comply. You understand me?
Yes, Your Honor.
All right. That's your only warning from me on this. All right, so I'll continue bonds this time. Yes. All right, do we need Mr. Copeland from the jail, or does counsel want to approach on that? Or, well,
We can approach.
okay.